Now, y'all know this is Pride Month, and we have been going over the court cases that gave our lovely LGBTQIA plus siblings basic rights, like the right to get freaky in the privacy of their own homes. I know, that was actually a thing. It was illegal for them to do that. Yeah. But I digress. I was about to go off on a tirade. What we are discussing is the basic right to get married. Because that was a thing too. For a very, 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 very long time, they could not get married. Yeah. So we are working our way up to Obergefell versus Hodges. But before we do, we've got some legislation and some court cases to discuss. Yeah. Now, I said that there were just two things that we needed to discuss. Defense of Marriage Act, or DOMA, and United States versus Windsor, totally forgetting about the fact that they tried to pass an amendment saying that marriage is just between a man and a woman. The Federal Marriage Amendment. I'm not kidding. So let's discuss the Federal Marriage Amendment. The Federal Marriage Amendment was a proposed amendment to the United States Constitution that would legally define marriage as a union of one man and one woman. The FMA would also prevent judicial extension of marriage rights to same-sex couples and prevent updates to the Constitution to extend rights for same-sex marriage. It read, "Marriage in the United States shall consist only of the union of a man and a woman. Neither this Constitution or the Constitution of any state, nor state or federal law, shall be construed to require that marital status or the legal incidents thereof be conferred upon unmarried couples or groups." It was first introduced in 2002. It's been introduced 8 times, most recently in 2015, and obviously it has not been successful. When it was introduced in 2003, there was an objection because it would interfere with Massachusetts' experiment with same-sex marriage, then scheduled to begin in 2004. After some back and forth, the FMA was reintroduced in 2004 with the following verbiage. Marriage in the United States shall consist solely of the union of a man and a woman. Neither this Constitution nor the Constitution of any state shall be construed to require that marriage or the legal incidents thereof be conferred upon any union other than the union of a man and a woman. They wanted to make it very clear that they felt it should be between a man and a woman. So they made it, they just repeated it. Yeah. In 2004, then President George W. Bush endorsed a proposed constitutional amendment to restrict marriage to opposite-sex couples because he found DOMA to be vulnerable. The Defense of Marriage Act that was passed in 1996, it did 2 important things, right? It said that states did not have to recognize same-sex marriages performed in other states, because at the time, the full faith and credit clause meant that same-sex marriages performed in any state had to be recognized in every state. And DOMA said, not anymore. No. You don't have to recognize the same-sex marriage that was done in Hawaii. And 2, DOMA defined marriage as being between a husband, male, and a wife, female. So Bush was like, After more than 2 centuries of American jurisprudence and millennia of human experience, a few judges and local authorities are presuming to change the most fundamental institution of civilization. Their actions have created confusion on an issue that requires clarity. Well, they needed 290 yay votes. They only received 227 yay votes. So the amendment failed. The amendment was reintroduced in 2005, 2006, 2008, 2013, and 2015. And it failed every time. You noticed that, didn't you? You noticed that they introduced the FMA in 2015, the year of Obergefell and Hodges. The audacity. For those who don't know how these politicians could have the nerve, you'll soon find out. We're headed there. We're headed there. Okay, so fun fact. In a 2003 State of the Union address, Bush Sr. alluded to the recent court decision in Massachusetts ordering the state to recognize same-sex marriages beginning in May. He says activist judges have begun redefining marriage by court order without regard for the will of the people and their elected representatives. If judges insist on forcing their arbitrary will upon the people, the only alternative left to the people would be the constitutional process. Meanwhile, his vice president, Dick Cheney, neither endorsed nor condemned the FMA, arguing that same-sex marriage is an issue for the states to decide. In 2009, Cheney stated his support for same-sex marriage on a state-by-state basis.